Hey guys, it's my Cafe, and I finally had time to go through the XRP ruling with you guys. I just wanted to review this because a lot of people were making statements that weren't true from the document. So I just wanted to go through things so you understand as well, because you know that's what I love to do. 1 second. So yeah, I actually thought that this ruling was very, very fair. Not fair from the context of that the judge, they did review it from the perspective that was asked. And they had a very she did what the SEC asked for, which is to basically review it from the context of the Howey test and basically go through the SEC's accusations as listed. And what she found was based upon everything they asked. So it's just kind of crazy how the SEC has a problem with it. But really, it's honestly the SEC's fault for not being very clear. And again, I've said from the beginning, this lawsuit was done, like the claim was done inappropriately, trying to call the asset a security when you haven't established a basis for what a crypto security would look like. That doesn't make any sense. And again, as you know, the token has nothing to do with the miners and developers. Like the token price versus that, it's two different situations. Like a token can have like the best technology in the world, Chainlink, and its price does not reflect that. So, a loose argument that probably led to one of like the demeaning, one of the fatal, the finalization of what the judge saw is it's not true, and you can't make things up to negate like your view to win a lawsuit to label all token-based assets security. I think it was a very poor strategy, and it did not work out for the SEC, and they were too broad. If the SEC would have went directly for institutional sales and then try to go through this space, like, okay, which one had institutional sales that funded development, that's a little different, right? That's a thing. The issue is like the SEC wanted to label the token as security, and it's like, what are you doing? Like, again, institutional sales was their whole base and merit. The fact that they weren't specific within this lawsuit is the reason why it did not go the way they went. And when you're not so specific, you open yourself up to a legal situation where, okay, we're going to see what you're saying and we're going to prove that you're wrong. And that's exactly what happened here. And even if they do appeal and fail again, it looks really, really bad from the perspective of the SEC, because there's a different way they could have approached the situation, and it could have been direct with their complaint instead of making up things and then locking this token in a financial chokehold for about 3 years. But cool, let's go through it. So plaintiff, the Securities and Exchange Commission, brings this action against defendant Ripple Labs and two of its senior leaders, Brad Garlinghouse and Christian A. Larson, alleging the defendants engaged in unlawful offer and sales of securities in violation of Section 5 of the Securities Act of 1933. SEC also alleges that Garlinghouse and Larson aided and abetted Ripple's Section 5 violation. Before the courts, the parties are cross motions for summary judgment. So the SEC motion was granted in part and denied in part. The defendant's motion is granted in part and denied in part. And we're just going to go over that and explain what that means. So just do quickly, because maybe some of you guys, again, like I'm not a maxi of any project. I respect the technology, and that's how I judge engaged projects. So projects that are fully decentralized, for the most part, that didn't have heavy VC funding in the beginning, I generally support them. I think they are projects that I look at Ripple. They were going through this whole thing, and they still had things going on, like things were still being developed outside of this, like nothing stopped. And that's the whole point. Like this can happen and a decentralized project will still exist. And that's what we're trying to explain to them. Like the token has nothing to do, the token's price and value doesn't have a lot to do with the founding contributors. And people that don't understand that clearly don't have an understanding of that. So it's like talking to a wall to sometimes with these people. So the development of XRP Ledger and the founding of Ripple in 2011, 2021, Arthur Brito, Jed McCaleb, and David Schwartz developed a source code for cryptographically secured ledger, or a blockchain, which is now known as the XRP Ledger. They aim to create a faster and cheaper and more energy efficient alternative to the Bitcoin blockchain and the first blockchain ledger, which was introduced in 2009. When the XRP ledger launched in 2012, the source code generated had a fixed supply of XRPs. So it was pre-mined. And so there's that. XRP is a native digital token of the XRP ledger, and the XRP ledger requires XRP to operate. Each unit of XRP is divisible into 1 million drops, and each unit or drop of the XRP is fungible with any other unit or drop. In 2012, Brito, defendant Larson, and McCaleb founded Ripple. Larson became Ripple's CEO and held that position until 2016. And then out of the 100 billion XRP generated by the XRP ledger code, the three founders retained 20 billion for themselves, including 9 billion for Lawson, and provided 80 billion to Ripple. The founders did not sell any XRP before the launch of the XRP ledger, and Ripple never owned XRP retained by the three founders. So this is very important because basically the founders gifted both Ripple and themselves tokens. Nothing was sold, it was gifted, which is like a peer-to-peer transaction. Let's start there. Since its founding, Ripple's mission has been to realize the internet of value by using the technology to facilitate the transfer across the internet. Specifically, Ripple seeks to modernize international payments by developing a global payment network for international currency transfers. For instance, Ripple developed a software product called RippleNet, which allowed customers to clear and settle cross-border financial transactions on mutually agreed upon terms. One feature of RippleNet is known as on-demand liquidity. ODL facilitates cross-border payment functionality and transactions by allowing customers to exchange fiat currency for XRP and then XRP for another fiat currency. Like ODL, but not all of it, Ripple's products and services rely on the XRP ledger and XRP. The XRP ledger is based as an open source software. Anyone can use the ledger, submit transactions, host a node to contribute to validate transactions, and propose changes to the source code or develop applications that run the ledger. Other developers have built software protocols that use XRP ledger, such as payment processing applications. Ripple has also funded companies and part of its XFree initiative to incentivize development of other use cases on the XRP ledger. Okay, so before the end of 2020, Ripple owned about 50 and 80 billion XRP. All parties disputed the specific dollar amount as we read through 2013, the end of 2020. Ripple engaged in various sales and distributions of XRP, and herein lies some technicalities and issues. First, Ripple, through wholly subsidiaries, sold XRP directly to certain counterparties, primarily institutional buyers, hedge funds, ODL customers, for written contracts of institutional sales. So this is the technicality, and this is the one specific issue that I have with most projects. Selling to institutions and VCs and allowing them to hold the cryptocurrency and dump on retail is one of my pet peeves. And often when I judge a project, I see how much token allocation has this project given to VCs. I understand that everyone needs money, but at what cost? Like, these people don't care about crypto. I know a few people that have worked with VC firms related to crypto projects, and literally, and this is another issue I have with the SEC. They should have targeted, VC should have been literally the point of issue, because they were funding anything and everything. And people thought, well, if this project is well funded, it's going to do well, it's going to grow in price, I'm going to make money off it. And I was like, that's because if it doesn't have technical strength, if it's not, no one uses it, no, they just have a really good marketing team because they can afford it and X, Y, and Z. The issue is like VCs, there were no restrictions with them. There was none of that. So it's like the SEC complains and bitches all the time, but it's like in reality, if you guys would have set up a structure or attack specific issues, we could have had some form of like clarity, like, let's get on VC allocation. Like, you guys can't invest all this, get the token. You can't invest without having a locked token for a period of time. Like, that's one rule. I'm cool with that, because I don't appreciate how, like, when it's at a all-time time, VCs are just dropping on the price and they exit and no one really cares about the project post that. That's a huge problem in crypto. So yeah, they sold it and they used written contracts. But again, like, the SEC didn't propose any type of rules before this situation. So how would they have known? Like, I think that's not okay. But again, if something is not illegal, how are you going to say it's a crime? Like, you know, like it's frowned upon. Like, I don't know if it's frowned upon. I frown upon it for a technical basis, but like, unless they've been told clearly by the SEC, like, how are they supposed to know that they can't do that? And then I guess that goes into the fair notice defense, in which Judge Torres, or we're gonna go over that later, but she basically said, like, you don't get fair notice because you shouldn't have done it. And I'm like, okay, but like, that doesn't answer anyone's question. So the SEC alleges that Ripple sold approximately 72.89 million of XRP to these institutional sales. Second, Ripple sold on digital asset exchange programmatically through the use of trading algorithms, programmatic sales. Ripple's XRP sales from the digital assets were a bid and ask transaction. Ripple did not know who was buying the XRP, and the purchasers do not know selling, because that's true. A lot of people still don't know anything about Ripple when it comes to XRP. All they know is the XRP ledger. We love XRP, XRP Army. That's all they really know, which inherently goes against the Howey test and saying that they're all a common enterprise and they're all buying it because they know about the technical. No, the people don't know about Shiba Inu. They just buy it. So it's like, again, that's why I don't feel like half the tokens are applicable to the Howey test, because it just doesn't match the prongs and it's not fully applicable. You can't be specific about one context of it for a lawsuit. And if the shoe doesn't fit, we must acquit. So yes. The SEC alleges that Ripple sold approximately 757 million of XRP in programmatic sales. Ripple used the proceeds for institutionals and programmatic sales to fund its operation. Also gave XRP as a payment for services and other distributions. For example, Ripple distributed XRP to its employees in front of employee compensation. So they just gave them tokens. The same thing you would do if it was a grant, the same thing you would do if it was a gift allowance. It's peer-to-peer, not a big deal, no one cares. Ripple distributed XRP in conjunction to XRP, it's an initiative to fund third parties developing applications for XRP and XR Ledger. In sum, the SEC alleges that Ripple recognized the value of 609 million from the distributions of XRP to individuals and entities exchanged for services. In addition, Ripple sales and distribution, Larson's and Garlinghouse offered and sold XRP in their individual capacities. After stepping down as CEO of Ripple in December 2016, Larson became the executive chairman of Ripple's board of directors, a position he currently holds. From at least 2013 to 2020, Ripple sold XRP on digital assets exchanges programmatically and made at least 450 million from his sales, because he has the free will to do so. Garlinghouse was hired as Ripple COO in April 2015. After Larson stepped down as CEO, Garlinghouse became CEO effectively in 2017, a position he currently holds. From April 2017 through 2020, Garlinghouse sold XRP on digital asset exchanges, and the SEC alleges that Garlinghouse sold approximately 150 million XRP during this period. Garlinghouse has also received XRP as part of his overall compensation for Ripple. Defendants did not file a registration statement as offers or sales of the XRP. Ripple did not publicly file a transaction statement or any periodic reports, nor did it make an Edgar's filing to the SEC for Ripple, such as Form 10, Form 10K, Form 8K, or relating to XRP. Defendants' marketing claim. The SEC alleges that in 2013, defendants became extensive years-long marketing efforts to represent that they would search for the purported use and value of XRP and casting XRP as an opportunity to invest those efforts. The SEC points to a wide range of statements, including informational brochures, internal talking points, public blog posts, statements on social media, videos, and interviews with various Ripple employees, and more. Defendants dispute the SEC's factual narrative and argue that SEC cherry picks from documents with many authors, from public statements, and many speakers, made across an 8-year period of time to many audiences, which is true. Yeah, again, because people still don't know how what Ripple does or any of that, I think that's illogical and it's unrelated to the case itself. No one cares. So a weak argument from the SEC side. Okay, so Ripple and its senior leaders use a variety of social media platforms, including Twitter, For instance, Larson gave an interview in which he discussed XRP. Garland House was previously interviewed for media outlets such as Financial Times. I mean, are they not allowed to speak about their project? If I had a published project, I probably wouldn't talk about it because I'm very paranoid about like, you know, things. But I would love to get you can discuss something you're working on. I mean, freedom of speech, the free right. Like, I don't understand. I feel like they want everyone to be Satoshi, and it's like that's not possible for whatever reason. I mean, it's just kind of strange. It's like, how can you guys want transparency, but then you try to say, oh, you're marketing to a broad audience if the founder or CEO or CFO of a blockchain-based company that runs adjacent to the actual blockchain talks about the products and services. Like, do you want transparency or do you want secrecy? You have to decide. It can't be both, though. In February 2012, before the XRP ledger was launched, Ripple's founders, including Lawson's, received from the Perkins Cooley LP law firm memorandum, which sought to review the proposed products and business structures, analyze the risks associated with Ripple, and recommended steps to mitigate these risks. The memorandum analyzes, amongst other things, the legal risks with selling XRP. Specifically, it states if sold to investors, XRP tokens are likely to be securities. To the extent the founder's issuance of XRP does not involve an estimate of money, there is low risk that the XRP will be considered an investment contract. Okay, so it does point to subjugated awareness. However, the asset would have to be ruled as a security to make it a crime. You know, if that makes any sense? Like, if it's not a security, it's not a crime, it's a digital asset. So you guys need to make rules and regulations for digital assets and figure it out. Like, I get what they're trying to say in the realms of like why they don't believe in anything is inherently wrong with it. And I agree, due to the basis of like, you can't just make up laws. You can't just reinterpret it, a new asset, and squish it into securities law. Like, you guys have to make a separate something else for security, something else cut. You guys have to make a different type of jurisdiction for crypto-based assets. And trying to not do that has gotten us into this pickle that we're in today, where everyone's confused and it's going to hell. In October 2012, Ripple and Larson and others received a memorandum from Perkins and Cooley, which is sought to review the proposed features of the Ripple network and XRP to provide recommendations for mitigating relevant legal risk. The memorandum states that although we believe a compelling argument can be made for XRP tokens do not constitute securities under federal securities law, given the lack of application on case law, we believe there is some risk, albeit small, that the SEC disagrees with an analysis. Yeah. It's true, because there is no case law, so the SEC is trying to create case law that aligns with their beliefs that all tokens are securities, even if they don't really meet the full Howey prongs, which is inherently problematic because they just want a bunch of wins, but they're not clearly defining the asset itself, and that thus lies in the problem. The founders of Ripple promote XRP as an investment opportunity. Is more than likely the SEC will take action and argue that XRP tokens are investment contracts. So this is the one thing that I didn't like, but I can understand why the judge did that. Should she strike down the fair notice? So what Ripple was trying to say, that we didn't know this was a violation. And I agree, like, it's not clearly aligned that they can't sell XRP to institutions, even though I wouldn't recommend it. And I don't believe that's the best idea. And I don't think you should be working with institutions in majority part because they don't value the project or the space and they just dump. But I guess every girl needs money, or, you know, project needs funding, whatever. But I've always said this is problematic. But again, if they weren't identified, they weren't sent notices. And I guess that could be because it probably happened before anyone knew, right? Because there's nothing being filed, no disclosures, blah, blah, blah. But it's like, it happened, let's get over it. So the Ripple is saying that they didn't have noticed that it was conducted in violation of the law, in contravention to Ripple's due process rights. And the court also denied Garland House and Larson's separate motion to dismiss. The court granted in part and denied the parties' motions to preclude expert testimony. Before the courts or parties cross motion for summary judgment filed on September 13, 2022, the court has reviewed the amicus brief from Afghanify and Invest Ready. So there were other cases with the SEC with crypto, but I don't know if they were labeled securities in these cases. You have to go research this. Section 5 of the Securities Act, it is unlawful for any person directly or offer, sell, or buy or purchase a security unless a registration statement in effect has been filed with the SEC and has to offer such sales of security to the public. Again, we don't know if this asset is a security, so why would you file something if it hasn't been defined to fall within the realm of a security entirely? It could not partially fall as a security. It does not fully fall, so that, again, the gov does not fit, so we must acquit. To prove a violation of Section 5, the SEC must show that no registration statement was filed in effect with the transaction, that the defendant directly or indirectly offered this to sell or sold the security through the interstate commerce. The defendant does not dispute that they offered to sell or sold XRP through interstate commerce. They also do not dispute that they did not file a registration statement with the SEC for the offer and sale of the XRP. The court is whether the defendant offered to sell or sold XRP as security. Specifically, the SEC alleges that the defendant sold XRP as an investment contract, which is the type of security defined by the Securities Act. Defendant argued that they did not to sell XRP as an investment contract, therefore no registration statement is required. In the SEC WHA Howie, the Supreme Court held under the Securities Act an investment contract is a contract, transaction, or a scheme where a person invests in the money in a common enterprise is led to expect profit from the souls and efforts of the promoter or the third party, which is not inherently true because in XRP, in all crypto assets, it's likely to go to zero. So we don't rely on anyone. We're aware of that. In analyzing whether a contract or transaction or scheme is an investment contract, form should be discarded for the substance, and emphasis should be your economic reality in the total of circumstance. Yeah, an investment contract should be an investment contract. I don't understand what that means. It's like, I don't understand how securities law is very specific and then very vague at points in times. It's just anti-sensible, but in their summary judgment briefing, defendant advanced a novel and essential agreement to the test, arguing that in addition to the Howey test, all investment contracts must contain 3 essential ingredients: a contract between a promoter and investor for establishing the investor's right to the investment, which a contract imposes a post-sale obligation to the promoter to take a specific action for the investor's benefit, and grants the investor the right to share profits from the promoter's efforts to generate a return of the use of investor funds. See, that again would only apply to tokens allocated to VCs if they sign over a contract. But again, like there's a multitude of risks that inherently comes with that. And sometimes it is not based upon the success in the project. Sometimes it is literally based on random traders trading and buying XR, like the token. So again, they got a 50-50 window with this, but there's still some technicalities to as to where even within the allocation of tokens to VCs for startup funds, like, the court declines to adopt the defendant's essential ingredient test, which would call for the court to read beyond the plain words of Howey and impose additional requirements not mandated by the Supreme Court. It's very, very important. The Supreme Court needs to either modify the Howey test or create an additional Howey test for crypto-based assets. It's kind of like what we've been saying, and then the court can only see this case within the realms of the Howey test and see as to how it does apply or how it does not apply. The court sees no reason to do so. Neither Howey nor its progeny hold that an investment contract requires the existence of the defendant's essential ingredients. To the contrary, these cases make clear that the relevant test reflects a focus on the investor's expectation of profit from the efforts of others rather than a formal imposition of post-sales obligations on the promoter to grant the rights to share profits. The Supreme Court's use of profits in Howey is intended to refer to income or return. Edwards 540 U.S. at 394, the financial returns from the investment are not equivalent to the post-sale obligation or profit sharing. Thus, the court is not persuaded that the precedent supports the consideration of the ingredients in determining whether a contract transaction scheme or investment contracts under Howey. Defendants do not cite a single place that applied to their test. Defendants contend that the court should take the pre-1933 state blue sky law case in which Howey the court relied. According to the defendants, every pre-1933 blue sky investment contract involved a contract of post-sale on the promoter and the investment's right to receive profit. That may be so, but the Howey court relies on the state's court's definition of investment contract or a contract scheme for placing the capital laying out money intended to secure income from employment when fashioned the relevant test. Had the Supreme Court intended to incorporate these ingredients as essential requirements, it would have done so. In any event, even accepting the defendant's survey and analysis of the case law is accurate, the fact that the 1933 investment contract cases share some common features that does not convert to the common features and requirement necessary to finding an investment contract under Howey. Rather than the Supreme Court guided by fundamental purposes undergirding the Securities Acts, in which Congress painted a very broad brush, and recognitions with a virtually limited scope of human ingenuity. Reese Ernest, 94 U.S. 56. So to this, the court must be guided. Indeed, there are more than 75 years of securities law jurisprudence after Howey's court have found the existence of investment contracts, even in the absence of defendants' successful ingredients, including the recent digital asset case, SEC versus Kirk Negative, ABT coin. ABT coins do not entitle the purchases to a pro rata share of dividends. This makes sense given that the Howey test was intended to embody a flexible rather than static principle that is one capable of adaptation to meet the countless and variable schemes devised by those who seek the use of money of others on the premise of profits. Put differently, the Howey test was intended to effectuate the statutory process of affording broad protections to investors and protections that not to be thwarted by unrealistic and irrelevant formula. According, the court rejects defendants' argument that all investment contracts must include a post-sale obligation on the promoter and grants not reach defendants' first and essential ingredient that the contract must exist for the investment contract to exist. It's so stupid. I think the contract should exist for as discussed in greater detail below, in which instance where the defendant offered and sold XRP as an investment contract, a contract exists. Okay. XRP, the token, because this is the very important part. The plain words of Howey make it clear that investment for contract purposes in Securities Acts means a contract transaction or scheme. But the subject of a contract transaction or scheme is not necessarily a security on its face. Under the Howey, the court analyzes the economic reality and total circumstances surrounding the offers and sales of underlying asset. Howey and his prodigy have held that the variety of tangible and intangible assets can serve as a subject as an investment contract. Orange goes with Howey, whiskey cask, Glen and Arden, payphones, condominiums, beavers. In each of these cases, the subject of the investment was a standalone commodity, which itself is not inherently an investment contract. For instance, if the original citrus groves and Howey were later resold, those resales may or may not constitute an investment contract, depending on the totality of circumstance surrounding later transactions. Here, the defendant argues that XRP does not have a character in commerce of a security and is akin to other ordinary assets like gold, silver, and sugar. And she said no, because it would be considered a commodity. This argument misses the point because ordinary assets like gold, silver, and sugar may be sold as investment contracts, depending on the circumstance of those sales. Which kind of helped their argument. This is cool. Plenty of items have been used or consumed and have been the subject of transactions determined to be securities because they have the attributes of an investment. Even if XRP exhibits certain characteristics of commodity or currency, it may nonetheless be offered and sold as an investment contract. While helpful as a shorthand reference, the security in this case is not simply a digital token. which is more than an alphanumeric cryptographic sequence. This case presents a scheme to be evaluated under the Howey test that consists of a full set of contracts, expectations, understandings centered on the distributions of the gram. However, Howey requires an examination of the entirety of the parties' understandings and expectations. And this is the most important part. If you don't understand anything I said today, this was the core theme of the case, and that's what we're trying to say. XRP is a digital token. Is not in of itself a contract, transaction, or scheme that embodies the Howey requirement of an investment contract. Rather, the court examines the totality of circumstance surrounding the defendant's different transactions and schemes involving the sales and distribution of XRP. Each transaction must be analyzed and evaluated on the basis of the content of the instrument in question and purpose and intended to be served, and the factual setting as a whole, which is what I've tried to explain to a lot of people. I don't think crypto tokens are securities. I think the security is more of the security label is more of a transactional thing. Like, I don't think the digital asset itself was ever security. And the SEC leading with that as their core basis of navigating this lawsuit was pure stupidity. Like, you're going around labeling things tokens when, like, or securities. You could say humans are securities. My foot is a security. You're going to do this all day. You're going to go around walking around with a magnifying glass trying to label them, when the whole issue was the way in which these items were sold would constitute them as securities. And the fact that they have to have known that, right? The fact that they had known that and they went into a courtroom with this line of baseline for their lawsuit proves that this was never an argument about the asset being security. It was trying to establish case law to label most tokens securities, so henceforth you can set precedents upon that basis, which is why I don't agree with anything the SEC does, because it's not to protect investors. Because there's a various amount of rulings and statements and things you could have done to protect investors within the realms of corporate entities that are attached to these tokens. But to sit here and waste everyone's time for 3 years to call an item itself a security, which is really not important to the context of this whole argument, you wasted everyone's time, and it was a power grab, and it's very, very annoying. And I'm glad that people are seeing this and understanding this, and we can have arguments from this. We can have conversations from this base point. XRP, okay, we already talked about that. Each transaction must be analyzed and evaluated on a basis of content and the instrument in whole. This purpose is intended to serve and be a factual setting as a whole. The parties cross-move for summary judgment on the SEC's claim under Section 5 of the Securities Act. Whether the defendant offered and sold investment contracts is a legal question that the court resolves based on undisputed records. So they probably have the contracts for the XRP that was sold institutionally. So we can see their programmatic sales and digital asset exchange, which was separate from them, put it on exchange, people bought and sold. How does that affect Ripple in any way? Other distributions, underwritten contracts, consideration other than cash. The SEC also alleges that Larson and Garlinghouse engaged in unregistered individual XRP sales, from which they received at least 450 million and 150 million respectively. The court sales separately analyze and evaluate each category of transactions. Institutional sales. The court first addresses Ripple's institutional sales of XRP to sophisticated individuals and entities pursuant to written contracts. The SEC alleges that the institutional sales were distributions of XRP onto public markets through conduits, that some institutional buyers were buying XRP with brokers, while others simply resold it as a part of their trading strategy. That's a little tricky. The first prong of Howey examines whether the investment of money was a part of the relevant transaction. Here, the institutional buyer invested money from providing fiat or other currencies in exchange for XRP through its institutional sales. However, the defendant argues that the investment of money is different from merely the payment of money. Technically. And Howey requires not just payment of money, but the intent to invest that money. Not so. The defendant purportedly distinguishes that is not supported by case law. The proper inquiry is whether or not institutional buyers provided the capital, put up their money, provided cash, Defendants do not dispute that there was a payment of money. The court finds this element has been established as an investment contract. The second prong of how it exists as a common enterprise may be denoted through the showing of the horizontal commonality. Horizontal commonality exists when investors' assets are pooled and fortunes of the investors are tied with the fortunes of other investors, which as well as the success of overall enterprise. Horizontal community is a type of commonality that involves pooling the assets from multiple investors so that they all share in the profits and risks of enterprise. Here, the undisputed record shows the existence of horizontal commonality. Ripple pooled the proceeds of the institutional sales into a network of bank accounts under the names of various subsidiaries. Although Ripple maintained separate bank accounts for each subsidiary, Ripple controlled all of the accounts and used the funds raised for institutional sales to finance operations. Defendants do not dispute that Ripple did not segregate and separately manage investor funds or allow profits to remain independent. But what were they supposed to do with the money, though? Like, I hate when people give solutions with it, give problems, they don't give solutions. What would you rather have them done with the money? What were they supposed to do with it? I don't know. What were they supposed to do with it? Ripple's accounts are recorded all of the XRP related proceeds together. Further, each institutional buyer's ability to profit was tied to Ripple's fortune. That's not inherently true. And the fortunes of other institutional buyers, because the institutional buyers receive the same fungible XRP. XRP uses fund it received from institutional sales to promote and increase the value of XRP by developing users for XRP and protecting the XRP trading market. The value of XRP rose, all the institutional buyers profited in proportion. Ripple used the funds it receives from its institutional sales to promote and increase the success of the ecosystem drove the demand for the digital token, thus dictate the investors' profits. That's not inherently true. Inherently true. Because that's also the thing people don't understand. Not all tokens are going to rise in price. Not all tokens. That's not even their intention. There needed to be a pair of exchange and a metric to exchange money. You can correlate the price in terms of fiat at a later time, but that's a core thing. Everyone's oh my god, make it go higher. It's not going to go higher. Some of it has a minimal price range that's needed as a variation of exchange, making the assumptions that it will go higher within a given set time is why a lot of people do not do well when it comes to crypto. It's the expectation of a higher value with not understanding how did that even occur. Also, it's not a proof of stake token. It's already pre-mined. So again, people just okay. The success of an ecosystem drove demand for the digital token, thus dictating investors' profits. Not true. Finds horizontal communality where the digital token possesses identical instrument and the value of which is entirely dependent on the success or failure of the TON blockchain. The investors' fortunes are directly tied to the success of the TON blockchain as a whole. The court finds the existence of common enterprise because the records demonstrate there was a pooling of assets and the fortunes of the institutional buyers were tied to the success of the enterprise as well as the success of other institutional buyers. The third prong upon examines whether the economic reality surrounding Ripple's institutional sales led the institutional buyers to have a reasonable expectation of profit to be derived from the entrepreneurial or managing efforts for others. In this context, profit means income or return to include, for example, dividends or other periodic payments or the increased value of the investment. The reasonable expectation of profit from the efforts of others may not be the sole reason that the purchaser buys the investment or the asset may be sold for both consumptive and speculative use. Sometimes you're just going to buy for the tokens because you want to have them. I've done that before because I like fun. It's fun tokens. Moreover, the inquiry is subject to focusing on the promises offers made to the investors. That's interesting. It searched for the precise motivation for each individual participant. It's actually fascinating. Based on the total of circumstance, the court finds that reasonable investors situated in the position of institutional buyers would have purchased XRP with the expectation that they would derive profits from Ripple's efforts, which I don't think was inherently true. it doesn't work that way. The Ripple Communications marketing campaign, the natures of institutional sales from reasonable investors would understand that Ripple would use capital received from its institutional sales to improve the market for XRP and develop uses for the XRP line. Okay, that's a good technicality. But that doesn't mean it's going to increase the value of XRP. That's what everyone inherently fails to understand. It's like Bitcoin. Bitcoin's issuance is like one of the reasons why BTC goes up in value into issuance, holding, the amount that will be issued, the cap, like it's in its core design. So for one to say that like, oh, they did it because they know, it's like, well, they can clearly read a white paper and maybe they just agreed and believed in the project. That doesn't mean it would have been from the actions of others tirelessly working on the project. Oh man. Starting in 2013, XRP marketed XRP to individual investors, including institutional buyers, by distributing the promotional brochures that touted XRP as an investment tied to the company's success. Which is irrelevant because no one read those. Later, though, the XRP market reports XRP continues to connect XRP's price and trading to its own efforts. XRP Quarter 1 2017 reports that the company's efforts, including vocal commitment to XRP and the announcement of new business relationship, continuing the sign up to banks to commercially deploy its blockchain enterprise, joins the global payment network, may have had an impact on XRP's price to increase to an impressive trading volume. XRP markets report a highlight of XRP's dramatic and sudden price increases and notes that the market responded favorably to Ripple's escrow and decentralization announcements. Okay. XRP's liquidity was bolstered as a new case for XRP outside of cross-border payments. Not true. During this time, Ripple senior leaders echoed a similar statements on various public channels. We do have a very good job of protecting the value of XRP and the value of the network. It's a fair statement. Add the most value to the protocol. On 2017, David Schwartz, who was then a cryptographer. I don't know what's wrong with me today. I'm so sorry. My pronunciation is off. In 2018, he wrote on Reddit, Ripple's interests closely, but yes, not perfectly aligned with those of other XRP holders. I mean, is that a bad thing? I think this is me taken out of context. On February 2018, he posted on Reddit, what really sets XRP apart from any digital asset is the amazing team of dedicated professionals that Ripple has managed to amass a developed ecosystem around XRP. Again, I think taken out of context. In December 2017, Garland stated that XRP gave it a huge strategic asset to go invest and celebrate the vision for the internet of value. Okay, but that doesn't say like go invest in Ripple. That makes any sense. I don't know why you're trying to make these comments to a bad thing. It just believes if they believe in their project. I don't care. Also, the founders, stop giving interviews. Like, make your PR strategists do that. Like, all founders sitting on YouTube having interviews, like, stop doing that. Like, you can publish statements. That's the same reason why Gavin Wood stepped down as CEO for Polkadot. Because it's like, developers develop, your PR person PRs, like, they're going to take whatever you say out of context and it has nothing to do with the technology, so stop making statements. So it might be represented in your court case later. These statements and many more are representative of Ripple's overall message to institutional buyers about the investment potential of XRP and its relationship to the defendant's efforts. That is very strategic and taken out of context. Clearly, the institutional buyers would have understood that Ripple was pitching a speculative value proposition for XRP with potential profits to be derived from Ripple's entrepreneurial and manager efforts. Further, the nature of the institutional sales Ripple's leaders publicly emphasized the complexity of converting an internet value, the need for extensive capital to solve its trillion-dollar problem. Further, the nature of institutional sales also supports the conclusion that Ripple sold XRP as an investment rather than consumptive use. Not true. And this in some sales contracts, some institutional buyers agree to a lockup provision or resale restrictions based on XRP's trading value. That's kind of weird. These restrictions were inconsistent with notions that XRP was used as a currency or for other consumptive use. Simply put, a rational economic actor would not agree to freeze millions of dollars in purchase or interest rate if the person's intent was to obtain the substitute for fiat currency. I mean, no, that's done all the time with token allocations. It's just so like you won't sell anything immediately. I think that's fair. So I don't say that's a bad thing. Certain institutional sales contracts require the institutional buyer to identify Ripple for the claim arising out of the sales. Identify. What does that mean? Identify. Certain institutional sales and contracts required by the institutional buyer to identify Ripple for claims of arising out of the sales and distribution to XRP, and other contracts express state that the institutional buyers purchasing XRP solely to resell or otherwise distribute, and not to use XRP for any other purposes. The various provisions into the institutional sales contract supports the conclusion that parties did not view XRP as a commodity or currency, and they understood that sales of XRP would be investment in Ripple's efforts. I don't think it's true in the context. Therefore, having considered an economic reality and totality of circumstance surrounding the institutional sales, the court concluded. Therefore, having considered the economic reality in Therefore, having considered the economic reality and totality of circumstance surrounding the institutional sales, the court concludes that Ripple's institutional sales of XRP constituted an unregistered offer and sale of investment contracts in violation of Section 5 of the Securities Act. Programmatic sales. The court next addresses Ripple's programmatic sales, which occurred under different circumstances from the institutional sales. The SEC alleges that programmatic sales to public buyers, programmatic buyers on digital asset exchange. Ripple understood that people were speculating that XRP as an investment, and XRP as an investment, explicitly targeting speculators, and an increased speculative volume as a target goal. Having considered the economic reality of the programmatic sales, the court concludes that the undisputed record does not establish the third Howey prong. Whereas the institutional buyers could reasonably expect that Ripple would use the capital it received from its sales to improve the XRP ecosystem, thereby increasing the price of XRP, which is loosely based, partially can be believed to be agreeable, but not essentially proven. Yes, programmatic buyers could not reasonably expect the same because they didn't even know what Ripple was. They had no idea. They signed no contract. Indeed, Ripple's programmatic sales were a blind bid and ask transaction. The programmatic buyers could not have known if the payment or money went to Ripple or any other seller of XRP. The SEC responds in 2017, Ripple's programmatic sales represented less than the 1% of the global XRP trading value. 1%. Therefore, the vast majority of individuals who purchased XRP from a digital asset exchange did not invest money in Ripple at all. Shocker. An institutional buyer knowingly purchased XRP directly from Ripple's pursuant to a contract, but the economic reality is that programmatic buyer stood in the same shoes as a secondary market purchaser who did not know to whom or which it was paying money to or for. Further, it is not enough for the SEC to argue that Ripple explicitly target spectators, or that Ripple understood that people were speculating on XRP as an investment. Because a speculative motive on the part of the purchaser or seller does not evidence the existence of an investment contract within the meanings of the Securities Act. Yes.
But the expected return is not contingent upon the continuing efforts of another. No, people buy crypto. People bought Luna after the Do Kwon situations. They're special. They bought Luna 2.0. So clearly, people do not buy it because of the company that does projects around the current cryptocurrency is inherently not true based upon the numerous idiotic situations that we've had happen in the past year. The relevant inquiry is whether the speculative motive derived from the entrepreneurial or managerial efforts of others. It may certainly be the case that many programmatic buyers have buy XRP with an expectation of profit, but they did not derive that expectation from Ripple's efforts, as opposed to other factors such as general cryptocurrency market trends, particularly because none of the programmatic buyers were aware that they were buying XRP from Ripple. Of course, some programmatic buyers may have purchased XRP with the expectation of profits be derived from Ripple's effort. However, the inquiry is a subject of one focusing on the promise and efforts made to investors. It is not a search for precise movement and motivation of each individual participant. Here, the record established with respect to programmatic sales, Ripple did not make any promises or offers because Ripple did not know who was buying the XRP and the purchaser did not know who was selling it. In fact, many programmatic buyers were entirely unaware of Ripple's existence. The programmatic sales also lacked other factors presented by the economic reality of the institutional sales, which cut in favor to finding a reasonable expectation of profit to be derived from the entrepreneurial or managerial efforts of others. Yeah, it's true. Similarly, Ripple's promotional material, such as the Ripple Primer, I've never heard of that, and Gateway and brochure, I've never seen it, are widely circulated amongst potential investors like the institutional buyers. So there's no evidence that these documents were distributed broadly to the general public, such as XRP purchasers on digital exchanges, nor is there evidence that programmatic buyers understood the statement was made by Larson, Swartz, Garlinghouse, and other representations of Ripple and its efforts. Lastly, the institutional buyers were sophisticated entities, including institutional investors and hedge funds, and the examination of the entirety of the parties involved and expectations, including the full set of contracts, expectations, and understanding centered on the sales and distributions of XRP, supports the conclusion that reasonable investors situated in the position of the institutional buyers would have been aware of Ripple's marketing campaign and public statements connecting XRP price to its own efforts. There is no evidence that the reasonable programmatic buyer, who is generally less sophisticated as an investor, shared similar understandings and expectations and could parse through multiple documents and statements that the SEC highlights, which include statements sometimes inconsistent across many social media platforms and news sites from a variety of Ripple speakers with different levels of authority over an 8-year period. Therefore, having considered many economic realities and totals of circumstances, the court concludes that Ripple's programmatic sales of XRP did not constitute the offer and sales of investment contracts. Other distributions. The SEC's last category of the XRP offers and sales are other distributions under written contracts for which Ripple recorded $609 million in consideration other than cash in its audited financial statements. The other distributions include distributions to employees as compensation, as well as third parties of Ripple's Spring initiative to develop new applications for XRP and XRP Ledger. The SEC alleges that Ripple funded its projects by transferring XRP to third parties and then having them sell XRP to public markets. And that's the thing. And they have to prove that. I don't think you can prove that, like, they gave the XRP, they sold and they gave it back to Ripple. That's stupid. But I think what they're trying to say, because they gave it to them and they sold it, Ripple received the funds. And it's like, no, the person just sold it. Like, they sold their XRP for cash, for fiat. It's a taxable event. Go about your day. Like, that's the issue I have. It's like they took so many non-factual things and like literally put them into case law. So it's ignorant. Yeah. The other distributions do not satisfy Howey's prongs that there is an investment of money as part of the transaction scheme. Howey requires a showing that the investors provided the capital, put up their money, and provided cash. In every case, finding the investment contract, the purchaser gave up some tangible definition consideration in return for an interest that is a substantially characteristic of a security. Here, the record shows the recipient of the distribution did not pay or some tangible or definable consideration to Ripple. They've just received XRP To the contrary, Ripple paid XRP to these employees and companies. As a factual matter, there is no evidence that Ripple funded its projects by transferring XRP to a third project and then having them sell the XRP. Because Ripple never received a payment from these distributions because they were literally given as distributions to people who worked on various things. It's totally fine. It's not a payment. It's not a form of payment. I mean, it's a distribution, but they're not doing it to receive the conversion of the fiat from the sales of XRP that was distributed to Ripple, if that makes any sense. And that's what they try to say in this document, which is inherently ignorant. So I don't know. SEC is like, I don't know who submits these documents, but they need to like get it together. Anyway, in the opposition papers, the SEC pivots and argues and said that the other distributions that were indirect public offering. What is an indirect public offering? The parties that receive XRP from Ripple, such as a XRP X-Spring recipient, could transfer XRP in exchanges for units of other currency and goods and services to another holder. The SEC does not elsewhere allege that the recipient of other distributions, like Ripple's employees and third parties, were Ripple's underwriter. In any event, the SEC does not develop the argument that these secondary market sales were offers or sales of an investment contract. Particularly, they were the payment of money for the XRP sales, never traced back to Ripple, and the court cannot make such finding because it didn't happen like that. Therefore, having considered many economic realities and a totality of circumstance, the courts have concluded that Ripple's other distributions do not constitute as the offer and sales of the investment contracts. Larson and Garlinghouse offers and sales. Lastly, the court addresses Larson and Garlinghouse offers of sales of XRP. The Security Act exempts transactions by any other person other than the issuer, underwriter, or dealer. So Garlinghouse, they're not a issuer, underwriter, or dealer. They're just people who happen to work at Ripple. The SEC argues that this exemption does not apply to Larson and Garlinghouse because they are affiliates of Ripple. An affiliate or issuer, an affiliate of the issuer, such as an office director, controlling shareholder, ultimately may not be relied upon Section 4 exemption. So you're saying they can't be exempt because they work for Ripple, but that doesn't make sense. The court does not reach this issue. Like Ripple's pragmatic sales, Larson and Garlinghouse's XRP were pragmatic sales on various digital assets through the blind bid and ask transaction. Larson and Garlinghouse do not know to whom they sold XRP, and the buyers do not know the identity of the seller. Thus, the matter of law, the record cannot establish that the Howey prong as to these transactions for substantial, at least some reasons discussed above. Larson's and Garlinghouse's offer and sale of XRP on a digital asset exchange not amount to the offers and sales of investment contracts. Defendants' due process defense. Defendants each assert fair notice, claiming the SEC violated their processing rights. Larson and Garlinghouse also assert as implied vagueness defense upon the same due process principles. And then, like, you have to know that you're breaking the law before you're served a summons saying that you're breaking the law, which inherently, in the context of like committing a crime, they don't have to notify you, but like, I guess they do, right? Like when you're getting read your Miranda rights or whatever. I don't know. I'm probably messing this up, but law fails to comport with the due process when they fail to provide a person of ordinary intelligence fair notice as to what is prohibited, are so standardized that they authorize and encourage serious discriminatory efforts. The assessment cannot be conducted on the abstract. Rather, the party claiming to lack fair notice must show that the statute in question provides insufficient notice to his or her behavior was prohibited. The evaluation of any fair notice defense is objective, and it does not require into whether the party actually received a warning or alerted him to the danger to be held accountable for the behavior in question. The court rejects the defendant's fair notice and vagueness defense as to institutional sales. And the case law defines the investment contract provides a person of ordinary intelligence opportunities to understand what conduct it covers. Howey sets forth a clear determination to constitute what an investment contract, and a Howey prodigy provides guidance as to how to apply the test in a variety of factual scenarios. It is not the language of the statute that can provide a requisite fair notice. Judicial decisions interpreting the case will do so as well. Secondly, the case law articulates sufficiently the clear standards that eliminate risk of arbitrary enforcement. How is this an objective test that provides a flexibility necessary for the assessment of a wide range of contracts, transactions, and schemes? The defendants focus on the SEC's failure to issue guidance on digital assets and inconsistent statements as it approaches to regulating sales of digital assets as investment contracts. But the SEC's approach to the offended, at least to the institutional sales, is consistent with the enforcement actions the agency has brought relating to the sales of other digital assets to the buyers pursuant to written contracts in the purpose of fundraising, which literally should be the SEC's only qualm with crypto. And then like other illegal stuff falls into like other legal jurisdictions, but like literally they should only focus on institutional sales. Like it would have given them legitimate cases. Court asks whether the law presents an ordinary person with sufficient notice of the opportunity to understand what conduct is prohibited or prosecuted, not whether or not particularly has actually received a warning to alert him to the danger of being held accountable for the. So they're saying we don't have to send you a notice, which is like. According to the SEC's motion for summary judgment is granted to the institutional sales, but otherwise denied, and the defendant's motion for summary judgment is granted as to programmatic sales and other distributions and Larson's and Garlinghouse sales and denied as the institutional sales. The SEC also moves for summary judgment on the aiding and abetting of claims against Larson and Garlinghouse to establish liability for aiding and abetting the securities violation. The SEC must show, and this is a very important thing a lot of people missed, because a lot of people are like, oh, Larson and Garlinghouse are in hot water. And I'm like, actually, if you look at this, so the SEC moves forward a summary judgment on aiding and abetting claims against Larson and Garlinghouse, but the SEC must provide the existing of securities law violation by a primary as opposed to aiding and abetting party. So they have to show that these two people violated the securities law. They have to physically show that they specifically did it, not like Ripple board, not the Ripple lawyers, like they did it. It's going to be very hard to prove. Then the knowledge of this violation on the part of the aid and abetter. Again, how can you prove that they knew if you can't even prove that they specifically violated the securities law? And then the substantial assistance by the aider and abettor to the achievement of the primary violation. So it's like, how do you on paper prove that these two people did it? That's funny because it also makes the SEC work. It's like, you guys can't just throw accusations and see which one sticks. You have to come with substantial evidence that aligns with your claims, and the SEC refuses to do so. Henceforth, why all their lawsuits suck and they don't really show up very well in court. Courts cannot consider the three requirements in isolation from one another because the satisfaction of the knowledge requirements will depend on the primary liability, and thus there can be a nexus between the degree of knowledge and requirement that the alleged aider and abettor rendered substantial assistance. I think they're going to have a really hard time proving this in court. And indeed, the courts have found a high degree of substantial assistance may lessen the SEC's burden of proving Simon-Tier and vice versa. As to the first requirement, the court has already held that Ripple's institutional sales constitute of an unregistered security offering and the sales of the investment contract in violations of Section 5 of the Securities Act. With respect to the second requirement, to show the knowledge of Ripple's violation, the SEC must demonstrate Larson's and Garlinghouse a general awareness to their overall role in Ripple's illegal scheme. Yep. The SEC need not demonstrate that Larson and Garlinghouse were aware that Ripple's transaction schemes were illegal. Rather, the SEC must show Larson and Garlinghouse knew and recklessly discarded the fact that Ripple made transactions and schemes illegal under statutory and case law. Based upon the record, defendants have raised genuine disputed material facts as to whether Larson and Garlinghouse knew or recklessly discarded the facts that were made by Ripple's scheme illegal. It is not clear whether Larson and Garlinghouse knew or recklessly discarded securities law rather than laws under other regulatory regimes applied to XRP. Exactly. There are under other regimes that they didn't believe would be applied to XRP, so how could they know they were violating Securities Act? For instance, Larson and Garlinghouse testified that they did not believe XRP was a security because multiple foreign regulators, including regulators in Japan, Singapore, Switzerland, UAE, the UK, had determined XRP was not a security. Larson and Garlinghouse also stated that when the U.S. Department of Justice and the U.S. Treasury Department of Financial Crimes and Enforcement Network labeled XRP a virtual currency in 2015, they understood this is the official United States government the declaration that XRP was a currency and exempt from U.S. securities law. Larson further testified that he understood that the 2018 speech by the then director of the SEC Division of Corporate Finance, Bill Hinman, in which he stated that neither Bitcoin or Ether, another digital asset, were securities, to further reinforce the SEC's position that XRP was not a security. In October 2012, Perkins quoted a memorandum which Larson reviewed and advised, although he believed that a compelling argument that can be made that XRP tokens do not constitute securities under federal securities laws, given the lack of apparent case law, we believe that there is some risk, albeit small, that the SEC disagrees with our analysis. Larson testifies that after receiving the memorandum, Ripple took specific steps to ensure compliance with the advice contained within the memorandum. Likewise, the defendants have raised a genuine issue of material facts as to whether Larson and Garlinghouse knew or recklessly disregarded the fact of each Howey element. For example, defendants have adduced evidence that Larson and Garlinghouse did not know that Ripple's institutional sales at XRP satisfied Howey's common enterprise element because they did not believe the proceeds from the sales were pooled and understood that Ripple did not manage or operate or control the XRP ledger or the broad XRP ecosystem. Based upon the disputed facts in the record, however, the reasonable jury could find that Larson and Garlinghouse did not know or recklessly disregard Ripple's Section 5 violations. As to the third requirement, the defendant conceded that Larson, as Ripple CEO prior to 2017, provided substantial assistance, and Garlinghouse, after becoming Ripple CEO in 2017, provided substantial assistance. However, Larson claimed that he did not provide substantial assistance during the time of his executive chairman of Ripple's boards starting in 2017. That's interesting. To satisfy the substantial assistance component of aiding and abetting, the SEC must show the defendant in some sort associated himself with the venture, and that he participated in something that he wished to bring about, and that he sought by his actions to make it succeed. In other words, the defendant must conscientiously assist the commission of specified crime in an active way. Larson has raised a triable issue of material facts as to whether he proved substantial assistance beginning in 2017. The record establishes that starting in 2017, Larson moved away from the day-to-day operation roles at Ripple. After he stepped down as CEO, Larson also continued his role on the XRP sales committee, which approved Ripple's sales of XRP. The court concludes, therefore, a reasonable jury that could find that 2017 Larson did not consciously assist Ripple's Section 5 violations in some active way. According to the SEC's motion for summary judgment, aiding and abetting claims against Larson and Garlinghouse are denied. Conclusion. The SEC's motion for summary judgment is granted as institutional sales but otherwise denied. The court shall issue a separate order setting a trial date and pre-trial deadlines for due course. Yeah, so I think it was fair, and it was actually a win-win because now the SEC, they're like, okay, well, if you're mad about something, you have to show proof. The SEC hasn't been required to show proof and is allowed to make these claims, and it's just like, you guys have to follow up with substantial evidence before you launch these lawsuits, and that's the whole issue. And recently, Binance's lawsuit, when they tried to freeze their accounts, they had no viable proof that accounts have been commingled. So it's like, you guys can't keep launching these claims without viable proof and letting the court do your work. And I'm really kind of happy that it's a weird split decision, but even this being, the SEC has to prove that, Larson and Garlinghouse were aware and actively pushed it, knowing that it was a securities violation, when that's going to be very hard to prove. So I think it was a very, very fair, I think it was fair for the most part. And if the SEC tries to appeal it, it'll just show that they just want the asset to be ruled a security, because that fatal flaw has ruined their legal defense for nearly 75 to 80% of all their cases. Because as you remember, they were suing, and which is for all these cases, they were fraud, even the Do Kwon, but they have to include the securities title, right? Because they've been trying to get a securities label on one of these assets, so then they can be like, well, these tokens are securities. Now we make the land of the law in crypto because they're securities. And that's what they've been trying to do. And I've been trying to tell everyone, it hasn't been about protecting investors. It's been about labeling these assets securities so they can facilitate laws and framework and do all this other weird stuff, instead of saying hey, institutional sales, this is the way you want it done. those are things that they can actively gauge and manage. I'm cool with that. Everything else is weird. You don't have that right. Congress hasn't given you the right. And for them to give themselves regulatory power above Congress is crazy. And the fact that no one's legally done anything about that is really weird to me. So like, I hope the SEC is eventually held accountable by providing themselves regulatory powers not provided to them by Congress, because it's not okay. We can't all just go to work and make up new job functions, like it's weird. So yeah, so I hope this helped you guys understand it. A lot of people are saying different things on the internet because they are Bitcoin maxis and they hate everything, or just because they don't respect different cryptocurrencies as a technology as a whole. So I've seen a lot of people like put out weird narratives that are they're not true according to the case law provided in this document. And I'll leave it in the comments so you can review it for yourself. But when we're talking about these subjects, refer to case law and refer to documents. Don't refer to people's opinions when they prove that they have a bias and they're not open to exploring all blockchains as a technology. Okay. Thank you guys. If you watched this whole video, sorry that it was really long, or if I was a little boring, apologize. But I will see you next time. Thank you for watching. Bye.